Recording button. And David, I'll just do a quick introduction and then I'll hand over to you. So welcome everyone to the next webinar, the Law and Downtown Business webinar for the Ross Parsons Centre for Commercial, Corporate and Taxation Law here at Sydney Law School. My name is Jason Harris and I'm Professor of Corporate Law here at Sydney Law School, and I'll be chairing the webinar tonight. So the topic of tonight's webinar is schemes of arrangement and debt restructuring, and this is a very topical webinar. Some of you might be familiar with the recent amendments that the English Parliament has passed to facilitate debt restructuring in that jurisdiction, and that's certainly something that has great interest for us here in Australia, where creditor schemes of arrangement are used for some interesting and innovative debt restructuring. So we're always looking for new ideas and to test out how things are working in other jurisdictions. Of course, the Australians in the audience would be aware that the federal government has recently announced some small business restructuring reforms. We haven't seen the legislation for that yet, but that's looking at a modified debtor in possession regime. So we'll watch with interest to see what the final reform provisions actually say with that. So that's very much the topic for this evening, is looking at restructuring, trying to help businesses exit out of the post-pandemic environment. And tonight we've got a panel of experts from global law firm Allen Overy. So we have David Walter, who's a partner here in the Sydney office of the Asia Pacific Restructuring and Recovery Group. David, of course, is well known to many of the Australians in the audience. He's one of Australia's leading insolvency and restructuring lawyers, and he's been recognised by Chambers, Legal 500, Best Lawyers and Doyle's Guide. Joining him tonight is Jennifer Marshall, who's a partner in the Global Restructuring Group at Allen Overy, based in London. Jennifer's the chair of the City of London Law Society's Insolvency Subcommittee. She's a former president of the Insolvency Lawyers Association and a general editor of Sweet & Maxwell's Loose Leaf Cross-Border Insolvency Service, and a contributor to Lightman and Moss on the law of administration and receivers. And joining Jennifer and David, we have Rishi Hondocha, who is counsel in Allen Overy's Asia Pacific Restructuring and Recovery Group. He is based in Singapore and he works with A&O's offices throughout the Southeast Asia. He's also worked extensively in the London office. Unfortunately, our fourth presenter for tonight, Richard Woodworth, who's co-head of A&O's Asia Pacific Restructuring and Recovery Group based in Hong Kong, was unable to join us tonight, but we're in certainly very capable hands. So thanks to the A&O team for giving up your time tonight, and for Jennifer this morning to take us through creditor schemes of arrangement and some of the English law reforms. So I'll now hand over to David, who will facilitate the discussion. Thanks very much, David.
Jason, thanks very much for the kind intro. Thanks everybody for joining us this evening, and for those of you elsewhere, I guess this morning. And thanks to my colleagues at the firm for making time to talk with us all this evening. I promise you all that I won't be doing too much talking. Hopefully Jennifer and Rishi will be doing that. We'll certainly save some time at the end for Q&A and discussion. A few Australian perspectives maybe from Professor Harris and me as well. But without further ado, I wanted to get into the discussion with the team. As Jason mentioned, it's an interesting time in insolvency law around the world. We've just seen some modifications introduced here in Australia with a focus on small business, which have a bit of a UK flavour. They've got a UK CVA flavour to them for small business down here. But of course, at the big end of town, the UK has recently launched a device called the Restructuring Plan, which Jennifer is very well familiar with and which we'll come on to in a little while. But first of all, to open up the discussion just with a focus on what's been happening and developing in creditors schemes in the UK over the past year or two. Jennifer, did you just want to maybe tell us all about what's kind of, you know, new and flashy in the UK in schemes land these days?
Thanks, David, and thank you very much, Jason, for the very kind invitation to participate in this webinar. I think it's very sensible to start with schemes of arrangement, because the new restructuring plan legislation that we're going to talk about it very much builds on the scheme legislation, and actually there's a huge amount of overlap with schemes. Certainly from the perspective of a UK practitioner, I mean, we love our schemes of arrangement. So, you know, we sometimes joke that they're our greatest export in two senses. First of all, that other jurisdictions try to replicate them in their own laws. And secondly, we do love using schemes of arrangement in relation to foreign companies. So I thought I would say just three areas where we've seen the scheme really sort of develop over the last few years. The first is the continued use of the scheme for foreign companies. The second is the use of the scheme to release co-debtors, something which is close to Rishi's heart as well, because the Singapore courts are even better than the English courts at doing this. And then thirdly, I just wanted to say a little bit about a trend from some of the judges, particularly Mr. Justice Snowden, to try to preserve the English scheme, particularly in an international context, by making it very clear that this is not a rubber stamping exercise, and the court has a genuine role in granting sanction of the scheme. So I'll just say a little bit about areas in which the court has said, no, people are pushing the envelope a bit too far and are being a bit too free and loose with the use of the scheme. So just starting then with the use of the scheme for foreign companies, and particularly if the finance documents or the documents that are being schemed are subject to English law. And I should say this is not just to develop in the last few years. So this has been going on for the last decade or so. But certainly I think people are becoming more and more adventurous in the use of using an English scheme to compromise the debt of foreign companies. And just to sort of put this into context, the test for the English court is that you can have a scheme of arrangement in relation to a foreign company so long as there is a sufficient connection with the UK. And the case law has really developed over the last 10 years or so as to what sufficient connection means. And David, I don't know whether you're able to share the first slide, because I think this will just give an indication to people as to how much things have changed. So in the early days, and we're talking here about cases like Primacom, the early days, we're talking about cases like Leseda, which involved a Spanish company, or Rodenstock. Actually, David, if you want to just slip that back by that one, that slide there was just to show people who might not be less familiar with a scheme what a scheme involves, but this is the one I really want to talk to. So back in the olden days when we had cases like Rodenstock, which involved a German company, or Leseda, which involved a Spanish company, the English court was really looking for quite a substantial connection with the UK, in addition to having English law documents. So in both of those cases, most of the creditors concerned were based in the UK, and so it made absolute sense to use the English scheme. But this sort of sliding scale, which shows that the requirements have been getting less and less and less as time goes on. We take you to cases like Primacom and even Vinishin involving a Vietnamese company, Primacom involving another German company. And by that stage, really it was the English law documents which was what was sufficient for the court to find that it had jurisdiction. And there was no real, there were very few creditors who were located in England. Now, the reason that this is a tick rather than just a downward arrow is that in VGG, there was a suggestion that the court thought that perhaps people had gone a bit too far. And there was the suggestion that you might need, at least a few UK domiciled creditors in order to found jurisdiction in addition to the English governing law. And I think where we are now is that when you're trying to put together a scheme of a foreign company, you look for at least one anchor creditor, as we call it. So you look for at least one creditor who is domiciled or incorporated in the UK. If you have more than one, so much the better. But you use that anchor creditor as the way to get into the English court, and then that is able to compromise English law debts. The other one on this slide, which is quite interesting, is APCOA, because this was really the high watermark, I think, of the of using English schemes for foreign companies. Because in APCOA, it was a German company with German law governed docs and very few English English creditors. And so what the debtor did in APCOA was that it changed the governing law from German law to English law. And it relied on provisions in the documents that allowed a change of the governing law with majority lender consent rather than all creditor consent. And then once the law had been changed to English law, then APCOA applied for the English scheme and relied on sufficient connection based on the English law documents. So really, some have seen that as pushing the envelope to a very great degree. And it was only possible because in APCOA there was the ability to change the governing law with less than 100% consent of creditors. I think since that case, creditors have been quite live to that. And when putting together transactions, I think lenders look quite carefully at the change of law clause and what consents are required for that. I think the final thing I would say on this topic is that with sort of Brexit looming, and it looks sadly as if we are facing a hard Brexit for the UK at the end of this year, then I suspect that this area will become even more important. So we have a rule in the UK that is sometimes referred to as the rule in Gibbs, which basically says that you can only vary English law documents with the restructuring process or compromise process that is effective as a matter of English law. And certainly the English scheme is very effective as a matter of English law. Now, until now, if you had a German compromise proceeding or a French compromise proceeding, that would get automatic recognition under the European insolvency regulation. But when the UK is no longer required to recognise and give effect to that, then French compromises or German compromises will no longer be effective in the UK. And you may have to have a UK scheme in order to compromise the debt if it's English law governed. So just that David, if you just flick onto the next slide, this just shows just how many different types of foreign company we have utilised the scheme in relation to. And I mean, this only goes up to 2015 and does need updating. But even in 2015, we had used the scheme in relation to Spanish, Luxembourg, German, Italian companies, and then outside of Europe, we'd also used it in relation to Ukrainian companies and many others. So the scheme certainly is a powerful tool in that respect. Just dealing a lot more briefly with the other two topics. So the use of the scheme to release co-debtors. So imagine you have a scenario where you have different companies in the group, and you might have one that's the principal debtor, one that's a guarantor, for example. One option would be to have schemes in relation to all debtor companies, but that's obviously more expensive, and you have to go to the cost of making sure that those schemes interlock. But the question arises, could you just have a scheme of one of those group companies and then use that scheme to release the obligations of co-obligors? And in the UK, we have always been able to have a scheme of the principal debtor and use that to release guarantees. And the reason for that is that if there's a call on the guarantee, the guarantor will then have an indemnity claim or a contribution claim against the principal debtor, what's sometimes referred to as a ricochet claim. And so you use the scheme to release that ricochet claim and, in effect, to release the guarantor. The interesting development, though, is whether you can sort of flip that on its head and actually do a scheme of the guarantor in order to release the principal debt. Now, I personally think this might be going a little bit too far, but certainly it's something that has been possible in Singapore under a case called Empire Capital. And in the UK, we are doing something very similar, whereby we get the scheme company to adopt the obligations of the guarantors through some kind of deed poll arrangement. And then we use the scheme to release the obligations under the deed poll and then release the ricochet claims of the principal debtors. And that's been done in a case called Privet Bank and has been proposed more recently in Swissport. So it's a really interesting area, I think, and shows again the huge flexibility of the English scheme. And then my final point before I pass on the baton, which I promised to do, is just the role of the English court as what I would call the gatekeeper of the scheme, just trying to ensure that the scheme is not used and abused, particularly if we're wanting to sort of get recognition in other jurisdictions. And this seems to be a bit of a one-man campaign of Mr. Justice Snowden, one of our excellent insolvency judges, who spent a lot of his time at the bar trying to put together creative schemes that sort of push the envelope, and is now on the other side of the fence. And there's a wonderful expression that he is poacher turned gatekeeper in this role. But he has handed down a number of judgments recently where he said that people putting together schemes have to think very carefully about what they are doing. So in the Flint case, for example, where creditors were only given 14 days notice of what the scheme was purporting to do, he was very critical of that and said that there was no real evidence of urgency and that he didn't think in those cases that 14 days was enough. And that really creditors need to be given sufficient time to really consider the impact of the scheme on their interests. And the second case I wanted to mention in this case is a very, very recent case called Sunbird, where Mr. Justice Snowden actually refused to sanction the scheme, notwithstanding the fact that it had been approved at the creditor meetings, because he thought there hadn't been proper disclosure to the creditors. And I think this is a judgment he's been wanting to hand down for some time, and he's been looking for the right scheme to do it, to actually put down a marker here. He got very close on Noble, and he got very critical on Noble of some of the practices, but I think he realized that if he'd refused to sanction the scheme on Noble, then it could have brought down the group. Whereas this one, there were dissenting creditors, there were people who were aggrieved at what had been done, and so it seemed like the right case to put down a marker. So those are three, quite interesting areas of in relation to the English scheme. And with that, I will hand back to David.
Yeah, thank you. It's worth mentioning, I think Tiger Resources was the first instance of a guarantor scheme that happened down here a little earlier this year. So we've adopted that piece of technology down here in Australia, holus bolus, quite recently. Rishi, the reforms rendered to Singapore restructuring law more widely, but in particular to the scheme of arrangement procedure in Singapore are pretty widely reported on in this part of the world, and no doubt in the UK as well. Some of the things that have been introduced in the restructuring plan that Jennifer will talk about shortly, I think, are already there in the Singapore scheme reforms. How have you found sort of whatever it is, a year or two on post those reforms to schemes and also judicial management for those on the line, judicial management being somewhat like voluntary administration here in Australia and administration in the UK. How have you found those reforms work in practice over the last year or two since they were introduced, Rishi? Any watersheds?
Sure.
Anything interesting?
Thanks, David, and thanks to Jason for inviting me here on the panel today. I think it's safe to say that Singapore has a stated aim of making, Singapore government has a stated aim of making Singapore a regional restructuring hub, just like London and New York. So everything that's done in terms of the insolvency and restructuring framework stems from that stated aim to make Singapore an attractive region to restructure. And as you mentioned, the Companies Act was amended significantly in 2017, a few years ago, to enhance the Singapore scheme of arrangement regime and improve the restructuring framework. So some of the things that the restructuring framework introduced at that stage was an automatic moratorium when you file for a scheme of arrangement. And that moratorium is quite expansive in the sense that you could apply that moratorium up and down the chain in the corporate structure. The Singapore moratorium also extends to acts done not only in Singapore, but also outside of Singapore by people who are subject to the jurisdiction of the Singapore court. So it's extraterritorial in that effect. They've also introduced pre-pack schemes, so you can effectively have a scheme done without holding scheme creditor meetings, as long as you can show the court that you've got the sufficient support of the majority. So you could quietly negotiate a scheme with your supporting creditors and have it launched without notifying the whole world. And the regime's also introduced super priority rescue financing. So we've had 3 cases of rescue financing approved by the Singapore courts. So we're really taking a US approach, as well as taking the best bits of English law and kind of making a super powered scheme of arrangement that's, being widely used down here. And, in terms of how that's being used and how it's being implemented, I think in terms of the implementation, it's certainly used a lot by debtors here. It's as soon as the company applies for a scheme application, it will get the automatic moratorium protection. It doesn't even have to have a restructuring plan ready. As long as it can say, I am going to propose a scheme of arrangement and I've got some creditors who will support me, that is sufficient in order to get that moratorium protection. And if you look in the case of a very well publicized case of HiFlux, that applied for moratorium protection in 2018, and it's still going through moratorium protection, even though there's not really, if you want to be honest, any significant kind of developments in terms of the restructuring. And that's really given Singapore a little bit of it's kind of given it a little bit of a bad taste. It's made it perhaps too debtor friendly is the impression that we get from creditors. But actually it's a very powerful tool, and we've seen it used a few times, and the courts are, kind of using that in order to implement restructurings that otherwise wouldn't have worked. And Jenny mentioned Empire Capital, which was the first kind of guarantor scheme of arrangement that was implemented earlier this year. I mean, in fact, they went away. They started in 2019. They proposed a guarantor scheme of arrangement, and the court at the time said, actually, this works. The only thing is you haven't provided sufficient information to the creditors. So the company went away, got some financial advisors, put together all the financial information that was required, came around again and implemented a scheme that wouldn't have otherwise passed if you had 2 separate issuer schemes of arrangement. So the courts are really kind of taking an open and I'd say perhaps a pragmatic approach, but it really has become quite debtor friendly. And so the concern from foreign investors, if you like, is Singapore too debtor friendly? Kind of what protections do we have here? So the tool that we're now seeing that is becoming more prevalent is the judicial management procedure. And as you mentioned, it's very akin to the voluntary administration and the administration in England and Australia. And it's a corporate rehabilitation procedure whereby an independent insolvency practitioner steps in and takes control of the business and property and affairs of the business. Because COVID-19 has now stripped away the kind of financial bubble or the protections that a lot of companies had in the economic good times, you are seeing now judicial management being used, particularly where there's allegations of dishonesty or misdemeanor or fraud. So it's becoming an important tool for creditors to appeal to the court to say, actually, a scheme is not right here. There are significant concerns here around dishonesty and misdemeanor, and we want to appoint an independent judicial manager. We're seeing the courts move away from the kind of more rescue-orientated approach and siding with debtors to now taking creditors' side and saying, actually, here there is a good case for a judicial management process. Both tools are going to be incredibly important going forwards, particularly given the pandemic and how long it's lasting. But recently we saw an Indonesian company apply for a Singapore scheme of arrangement. So actually now the ambit is extended beyond Singapore. The Indonesian company had no real connection to Singapore, if you like. The debt was governed by US law. It was Indonesian centric. The businesses and operations were all in Indonesia. The only connection to Singapore was that the bonds were listed on the Singapore Stock Exchange. The Singapore court looked at that and said, that is substantial connection. That is enough. And actually, when you read the judgment, it says even having a retainer with a Singapore law firm could be enough to satisfy the substantial connection test. So it's very much moving towards the US focus and US kind of jurisprudence and trying to take the best bits of everything in terms of making it a regional restructuring hub. So it'll be interesting to see how that develops, but it's really kind of throwing itself out there as a restructuring hub.
Yeah, it's very interesting as an aside on the this picks up something that somebody just posed on the chat. I'm sorry I didn't get the name, but yeah, the debtor in possession model that is effectively facilitated by that sort of moratorium feature in the Singapore scheme. It works and is sort of socially acceptable for so long as the incumbent directors and management of the debtor are at least acceptable to the preponderance of the creditor group. Whereas if they're viewed as either negligent or fraudsters, the desire for external administration ramps up very rapidly. And you see a little bit of that type of trend in Australia, I suppose, with, albeit earlier stage, with some people now having a preference for secured creditors staying away from the appointment of receivers and instead allowing the kind of board-management selected voluntary administrators effectively remain in control and do their thing so long as they're viewed as being appropriately independent. So the sort of market practice shifting in the same direction there.
David, I also wonder if we've had some similar issues here in Australia a few years ago with holding dockers. The idea that you go into a restructuring regime, you're supposed to be putting forward a plan of restructuring, and actually the plan is we just need more time to figure out a plan. And, we've had our High Court here, our highest level of court, approve that as a valid use of voluntary administration.
Yeah, that's right. So since that Mighty River decision in the High Court a year or two ago, the holding docker effectively is just a moratorium CVA, to use the English phrase, and everybody just sits there for an agreed period of time.
There are some checks and balances. I mean, in Singapore, you have to have some kind of support from a creditor, but actually that's not it doesn't kill the process. It was tested in one of the recent cases where there was no creditor support. And typically you do that by having a major creditor sign a letter of support to say, we'll back this company until, it comes up with a restructuring plan. We think there's a viable underlying business there, which is the key to all restructurings. But the court in the case that came to court, there was no support from creditors, but the major creditor did not object, so it stayed silent, and that was enough. As long as there's some kind of semblance of hope that something can be restructured here, I think the courts will look quite pragmatically at it.
Yeah, it becomes about using in that case, the scheme of arrangement as a platform for the resolution of disputes, really about commercial matters like valuation and the compromise of claims, rather than actually implementing the compromise. Which again is a sort of often how Chapter 11 can tend to be used in the US. Jason's nodding furiously. Which, speaking of these models, Jennifer, it turns to the sort of core of the purpose for our discussion this evening. The UK restructuring plan, lay it on us. I mean, tell us, what are the highlights and the lowlights? How does it build on the scheme procedure? We're interested.
Thanks, David. So the restructuring plan was introduced into UK law in June of this year. So it is a very new and shiny tool, and it's already been used once in the case of Virgin Atlantic Airlines, which we were lucky enough to lead. So we got to be the first ones to test the new procedure. And I mean, I think what I would say about it is that it's been something that's been in contemplation for a very long time. So going back to 2016, there was a consultation in the UK about whether we needed a restructuring tool that had an ability to cram down dissenting classes of creditors. Because as people may be aware, if at the scheme of arrangement, you need to get the consents with 75% by value and 50% in number of each and every class of creditors. So if you have one dissenting class, which could be a junior class that's really out of the money, but that dissenting class can still block the scheme of arrangement to prevent the restructuring from going through. Now, we have ways of getting around this. So we come up with what I call the two-step dance, where the first thing you do when you're proposing a scheme and you've got dissenting out of the money creditors is that you transfer the assets away from those creditors, you know, perhaps by doing some kind of pre-packaged administration sale of the operating companies to a new co that's held by those who are still in the money. And then you use the scheme to allocate the equity in the new co. And so but you have to go through those two separate steps. And it's always been, I think, a great shame that you've had to do that, whereas in a Chapter 11, you can do absolutely everything through the plan. So that was the origin back in 2016, but then it got sort of tied up with Brexit and the fact that there wasn't really enough legislative space to do anything with the focus on Brexit, so it got sort of put on the back burner. And then the pandemic came along, and you know, that gave the UK government a real opportunity for coming up with a package of measures which were in part to deal with the pandemic. And so there were some temporary provisions that were supposed to give debtors who were struggling as a result of the pandemic a sort of a breathing space and greater protections from creditors. But at the same time, you know, if you're going to put an act through Parliament at great breakneck speed, you might as well slip in there the things that you've been trying to do since 2016. So that was the mechanism for getting the restructuring plan through. And it was quite incredible. There was a 250-page bill that included the restructuring plan, but all these other changes that went through Parliament in a month. And I think that must be an absolute record for the UK, and it's a huge testimony to the Insolvency Service, who are the executive agency of BASE, who were responsible for this legislation, that they got it through so quickly. You know, well, certainly from Virgin's perspective, we were very, very grateful that they did. So just what is the plan and what are its highlights and lowlights? And again, you know, I've put some slides together, not because I was proposing to talk to all of this, but for those, you know, who want to have a look at this afterwards, it will give you a bit more detail. And so in sort of short form, it's a new restructuring tool that has been introduced by adding a new part to the companies legislation, which is where the scheme of arrangement legislation sits. So Part 26 is our scheme of arrangement legislation, and there is now a new Part 26A, which is where the restructuring plan sits. Now, interestingly, it's not actually called the restructuring plan in the legislation. Part 26A deals with the arrangements for reconstruction and for companies in financial difficulty, but that is such a mouthful that practitioners have just ended up calling it the restructuring plan, or sometimes the super scheme, because it does have this cram down mechanism. And as I say, the reason why it was added is because although schemes are very powerful restructuring tools, very flexible, there isn't that ability to cram down a dissenting class. So like a scheme, it's available both for English companies and foreign companies which have a sufficient connection with the UK. So we're likely from a jurisdictional perspective to see it being used in a very similar way to a scheme. But there is an additional condition that the company must have encountered or be likely to encounter financial difficulties. So it's not an insolvency process per se. You know, it's part of the company's legislation and it's deliberately positioned in that way, but it is only available to companies experiencing financial distress. And in terms of process, it's very, very similar to a scheme. So David, if you can flip on to the next slide, you know, in terms of how you go about doing this, it's extremely similar to the scheme of arrangement, i.e. what you're putting together is a restructuring proposal that may involve either debt deferrals or debt write-off or conversion of debt to equity. It can be a compromise between shareholders as well as creditors. And that you then go to court to get permission to call your creditor meetings in exactly the same way as the scheme. One big difference though is that to get those meetings through, you only need 75% in value. There is no numerosity test, so you don't need to get 50% by number. And that's quite important, I think, if you've got you know, a couple of very supportive large creditors who between them do hold more than 75% in value. You know, it might allow you to sort of cram down a large number of smaller creditors. And then just as with a scheme, there is then a second court hearing after the creditor meetings where the court will decide whether or not to sanction the plan. And I've put here, again, I'm not going to talk to it, but there is a sort of an indicative timeline that shows how quickly you can put a plan together. I mean, on Virgin Atlantic, it was basically 6 weeks from the announcement of what we were trying to do through the plan to that plan actually being sanctioned by the court, and that you know was quick. Now we were lucky in the sense that we had evidence that this needed to be done urgently, that Virgin Atlantic was running out of cash as a result of the pandemic, and that if we didn't get the plan through by mid-September, then the company might have to end up in an insolvency process. And I think, you know, that evidence of urgency satisfied the court that we could go for a 14-day notice period before the convening hearing. I think it would have had to be much longer than that without that evidence of urgency. But the real feature of the plan and the real advantage of it is shown on the next slide, and this is the ability to cram down dissenting creditors. There are two ways of doing this. So you can decide to leave out of the plan out of the money creditors who have no genuine economic interest, and you can just decide that they've got nothing to do with you, so you can leave them out. I don't think that's very important, because I think you could probably do that under a scheme anyway, relying on sort of principles like the T-Corp principle. What I think is much more important is the one on the other side of the slide, which is that the court has the ability to sanction a plan, even if there is one or more dissenting classes, so long as these two conditions are met. And these conditions are therefore absolutely essential. So the first is you have to show that the members of the dissenting class would be no worse off under the restructuring plan than they would do if the company went into some kind of insolvency process or went into whatever is called the relevant alternative if the plan doesn't happen. So it's very similar to what we would call the comparator test in relation to a scheme of arrangement. And that is something that the court will look at in huge detail. So in terms of the valuation evidence, it's necessary to actually put before the court evidence of what will happen to the company if this restructuring plan doesn't happen. You know, is it headed for an insolvency process? Is there some kind of alternative plan that would be not so good for the debtor, but certain might be acceptable to the creditors? And how would the creditors fare in that alternative? And if they do better under that alternative than they do under the plan, then you can't use cross-class cramdown. And then the second condition is that you have to have at least one class that has a genuine economic interest that has approved the class. Now, just a word on that one, because on Virgin, we were very fortunate that when we held our creditor meetings, we actually passed the 75% by value for each class, and therefore we didn't have to rely on cross-class cramdown. I say fortunate because certainly from the client's perspective, we were all delighted about that. I suspect the market would have much preferred us to have to test it so that we could have had some case law on this, but you never want to be the guinea pig when you're doing the first one. But Mr. Justice Snowden, who we had for our sanction hearing, thought it was a good opportunity to say a few words about cross-class cramdown for when it has to be used next time. And one thing he made very clear was that he did not want people manipulating the classes to try to get cross-class cramdown through. So he didn't want you to sort of choose a class that, you know, everybody knew was going to be supportive of the restructuring. And then put them in the plan simply for the purposes of approving cross-class cramdown. And so this does call into the question, you know, the practice that we have used in the UK for many, many years of getting lock-up agreements or support agreements from creditors, so that when you go to court, you kind of have a good idea as to who's going to be supportive and who's not going to be supportive. I think the problem is if you get at those lock-up agreements too early, then there is a possibility that the court is going to say that you are manipulating the classes because you're putting in your consenting class simply for the purposes of using cross-class cramdown. So that's something I think practitioners are going to have to navigate quite carefully. I think the other thing I would say is that, you know, valuation evidence is going to become really, really important. And on Virgin, we had a financial advisor, Alvarez and Marshall, who prepared a very detailed model of what the relevant alternative was and why, and what recoveries would be in that relevant alternative. And they looked at that for each and every creditor, excuse me, just to show that each member of each class did better under the plan than they did under the relevant alternative. And, you know, obviously we didn't have to look at that in too much detail because we didn't rely on cross-class cramdown, but that evidence I think will come under a lot of scrutiny the first time this provision is actually used. Excuse me. So on my next slide, I just got a little example of how you could use cross-class cramdown. Excuse me. So this is a very, very simple example of a potential real estate structure where you may have, we've got 3 tiers of debt here. We've got the shareholders with a shareholder loan. We've got the super senior creditors, and then we've got the senior creditors. So that's a, you know, it would look very much like a 3-class restructuring plan there. And let's say the value breaks in the senior loan, so each of those classes has got a genuine economic interest in the plan. Then the question is, you know, can you, if you get the approval of the shareholders and the super senior, can you cram down the senior, or if you've actually got the approvals of the more junior creditors, could you actually cram up, the super seniors, can you actually use cram down to cram up a more senior class? And the answer is, well, yes, so long as you meet those two conditions. Subject, I think, to one very important point, which is that there seems to be no ability to impose new obligations on creditors. So you couldn't say to the senior lenders, for example, right, we're going to increase your loan to 600 and we're going to force you to put in 300 of new debt into the company. You couldn't do that because that's imposing new obligations, and that goes beyond the jurisdiction of both the scheme or the restructuring plan. But what you might be able to do is to say to the senior loan lenders, well, you may think you've got an event of default as a result of the plan, but we're going to override that and we're going to ensure that you continue to make your debt available. Now, that's quite an interesting question, because you'd have to show that those senior lenders do better under the plan than they would do if they took their enforcement action and enforced their loan. And again, this is where the valuation evidence, I think, will become absolutely essential. But if you give those senior lenders sufficient by way of additional interest to show that they're getting a better result under the plan than they would be, but for the plan, then that, in theory, is something that you might be able to do. And then I think the final slide is I just sort of put up some areas that the court is going to have to consider when looking at a plan. I mentioned the financial conditions and the fact that you're going to have to show that the company is in financial distress. The class constitution is exactly the same as the scheme, so that is well-trodden territory. Relevant alternative, I've mentioned you need to put forward evidence as to what would happen if the plan did not happen, and you have to show that no creditor would be worse off under the plan. You will have to show whether a creditor has a genuine economic interest, both for the purposes of excluding creditors if you want to do that, but also for the purposes of working out that you've got one in the money class that approves the plan. The court still has a huge amount of discretion in relation to whether to sanction the plan for being fair and equitable. And this was another very interesting point that came up on Virgin, because although I think I mentioned before that we no longer have the numerosity test, so so long as you get your 75% by value, you don't have to show you've got 50% by number. Having said that, Mr. Justice Snowden still wants to know how many creditors had approved and how many had not approved, because he said even though numerosity is no longer one of the conditions, he would have felt uncomfortable if we'd got one or two very large creditors to approve, but the vast majority by number were not approving. So it could well feed into discretion and fair and equitable, even though it's not part of the requirements anymore. Will the plan be effective in relevant jurisdictions? I mean, that's the same test really as for a scheme. So an English court is not going to sanction the restructuring plan unless it has evidence that that plan is going to be effective in the place of incorporation of the company or in places where the company has significant assets. And on Virgin, the biggest question we had was the US, where there were very substantial dealings. And so we dealt with that by getting what we call Chapter 15 recognition of the plan in the US. And that went extremely smoothly. The US court had no problem at all in seeing the plan in exactly the same way as it would do a scheme. And it gave that recognition. Now, of course, that was because Virgin was an English company, so it had its centre of main interests in England, which was part of the requirements for getting that Chapter 15 recognition. I think what could be more interesting would be if you have a completely foreign company and it's just English law governed debt that you're using as your way into the English court. It might be much more difficult to get your protection in the US in those circumstances. And I've mentioned valuation of the company, and then disclosure of information obviously was the point that came up in Sunbird. So we had something like a 50-page practice statement letter, and then an even more lengthy explanatory statement explaining exactly what the plan did. We hosted webinars to explain to trade creditors what the plan was trying to do. So we really did try to ensure that the creditors did have an awful lot of information about what the plan was trying to do. So in short, I think the plan is fantastic. The cross-class cram down, when used properly, is going to be a really effective feature. I still think people will carry on using schemes though, because I think they're familiar with schemes, they kind of know where they are with schemes. And I think people will only use the plan if they really think they might have to use that cross-class cram down.
Yeah, I mean, I was going to ask that question of, in practice, was it helpful having the hammer on the table, do you think? And it sounds like the answer is yes, Jennifer.
I think it was. I mean, I think we were lucky in the end that the trade creditors, who were the one class that we didn't quite know how they would vote, and I think in the end they did appreciate that, in some ways they were looking down the barrel of a gun. It was either the plan or it was an insolvency process where they would recover pence in the pound. And so it made it quite compelling, I think, for them to vote in favour of the plan. But it was helpful to be able to say to people, look, if we can't get this through consensually, we can use cross-class cram down. And so it was a good tool to have in the negotiating box, even though we didn't have to use it in the end.
Excellent. Well, thanks very much for the discussion, both. I see the time. Jason, was there anything that you wanted to put on the table from the Australian perspective? I mean, you and I have emailed about this offline. The existing, in quotes, cram down arrangements that we have down here are non-existent, and as Jennifer mentioned, sort of rely on the RE Corp line of thinking, which is less than ideal.
Yeah, I mean, I posted something up in the chat of an article that I wrote in 2017 looking at how creditor schemes worked in England, looking at how cram down worked in Chapter 11 in the United States, and just making the point that I think in Australia, at least at the time, and David, you're better informed on this as to current practice, but at the time it seemed like there were more and more foreign lenders coming into the local jurisdiction, buying out loans in terms of debt trading, and then they were looking to do some interesting things, and we'd seen some evidence of maybe some green mailing activity, particularly around mezz lenders. And so if we had a cram down mechanism in our scheme procedure, then that would deal with that, because even just the threat of that might discourage that sort of activity, and we might be able to get some more efficient restructuring outcomes rather than, as we've seen in some schemes, creditor schemes in Australia, putting up a proposal, having to go back to the drawing board because some Hong Kong-based hedge fund has come in and bought out a strategic stake in the notes and is then trying to frustrate the scheme just so that they can get a better deal. At least that's from my perspective as an academic external observer. I think a cram down mechanism would be really useful for getting better restructuring outcomes. But David, I'd really like your view on that.
Yeah, I mean, it's interesting that you're starting to see Australian entities turn to the US to restructure their affairs. Buccaneer Energy did it, I now lose track of time, but several years ago through a Chapter 11 plan, which was recognised down here under the Cross-Border Insolvency Act and given effect to. Likewise, you've got Speedcast over in the US at the moment in a Chapter 11, no doubt looking to do a plan, and also clearly having gone over and taken advantage of the super senior debtor in possession financing procedure that obviously the US, as it were, invented. So there is appetite and willingness to look abroad to implement restructurings using those tools. I keep wondering if the odd entity down here is going to start thinking about approaching the Singapore courts, because if entities down here don't have, for instance, Singapore governed bank debt or listed bonds, I mean, those are in the market, then as Jennifer touched on, in the course of the session, I can't see why it would be improper to change the governing law of those instruments to Singapore law, which isn't that different really to New South Wales law. It's not like it's scary, and using that as an excuse to go and access the Singapore courts, which are a very proper jurisdiction with capable people on the bench and capable professionals to help make these deals happen. So, I don't think, Jason, that this is the most important topic necessarily that confronts the Australian economy at large at the moment. But it's interesting to see, and what made me want to host this session, it's interesting to see that with a bit of determination and obviously a lot of, as Jennifer touched on, a lot of heavy-duty bureaucratic help, the English have introduced these measures in the space of a month. We've been thinking about it now for probably a decade, maybe more.
But David, just on that, I mean, one of the practical problems we have here in Australia is that to a certain extent we're making law reform on the run. So, I mean, even though the English provisions were introduced in somewhat record time, I mean, really they go back, as Jennifer said, to the pre-Brexit consultations. There was multiple rounds, there was detailed consultations, government responses, further consultations, further models put forward. We don't see enough of that in the Australian market. We tend to see thought bubbles raised, then getting shouted down in the media, and then all of a sudden here comes a form of law reform that nobody asked for. Really, this is something I've been banging on for years now, but really we need some sort of comprehensive back to first principles review of insolvency law and restructuring, because so many aspects of our law really are based on 19th century insolvency rules. And, we're in a global race for capital and restructuring capital. And at least in my opinion, I think we are losing that race. And we're going to see more and more restructuring work going overseas unless at some point we actually sit down and say, what's global best practice? What's working? What's not working? How do we make the procedure work better, rather than what we see far too often in the Australian market, in my view, is how do we do something but not do too much, because then we might give Phoenix operators a free kick.
Yeah, that's right. I mean, we've discussed offline that, you could cobble together effectively a sort of a useful out-of-court or scheme-driven cram-down in Australia using an amalgamation and reconstruction scheme and Re-T Corp in order to deal with dissentient mezzanine holders, for instance. And Jennifer touched on that type of idea while she was speaking. Like, you can cobble it together, but that's all you're doing, really. And I just don't see as a policy reason why that is particularly healthy. The US has an established market for dealing with cross-class cram down. The Singapore government saw fit to effectively adopt that. It's happened. The place hasn't caught fire yet, and now you've seen the UK roll it out, and again the place hasn't caught fire. So these things are doable. As you say, Jason, it's about just stepping back as a policy matter and asking yourself the question, what are we trying to achieve here? It doesn't seem to me that the sort of cross-class cram down is a particularly controversial proposition. If you ran it up the pub test flagpole and said, do you think it's okay for those that are already impaired to squash, with a great deal of expert evidence and judicial supervision, to squash those that are undoubtedly out of the money? Well, it's pretty uncontroversial, I'd have thought. Except for those approaching the situation in bad faith, and well, those people should have their views disregarded, frankly. So unless there were burning questions from the gang, we might look to wrap up. Bang on time, 7 p.m. Jennifer can get on with her day. Rishi can get on with his evening. I'm going to go and try and get out of here. But thanks all for joining us. And Jason, thanks so much for having us on. It was really terrific speaking with you.
Thanks so much. I really enjoyed the discussion. I've been following that English law reform for the past few years, so it's wonderful to get a local practitioner's perspective and then to get the comparative perspective with what's been happening in Singapore. So I did pass on some of those case references that Jennifer and Rishi mentioned. And as I said to the attendees at the start, the slides will be made available to all attendees, as will the recording for this session. So on behalf of Sydney Law School and the Ross Parsons Centre, thanks very much to the team from A&O for giving us an insight into some current and emerging developments in debt restructuring and schemes of arrangement. Thanks, Jennifer. Thanks, Rishi. And thanks again, David.
Thanks, everybody.
Thanks, Jason.
Thanks, everyone. Thank
Good
you.
evening.
Bye-bye.
Bye.
Bye.